But the word hostile has not been used anywhere in the Evidence Act. More particularly in section 145. Your Honor, kindly have
But then what is the procedure? I mean, how can a prosecutor cross-examine the witness called by him?
But 154 simply says you take permission to cross-examine for these reasons. Permission is granted to cross-examine, but witness is never branded as hostile. Hostile means it presupposes unbelievability of that witness. On oath, I am telling the truth. Why should you declare me as hostile? Why do you say that I am a false witness or I am a hostile witness? At that stage, if a witness is treated as hostile, he is seen as an untouchable. No, he is a hostile witness. Don't look into it. Suppose I am standing in the bus stand, I see an accident.
What is actually?
But I am summoned to the court, I come and give the evidence.
What is the evidence?
By a judicial pronouncement, you declare me as hostile. When I return, you say that you are an unfavorable person. Go back.
No.
Who will come to the court hereafter to give you evidence?
I'll see.
Last year submitted that the last course available for a prosecution is to prove either demand or receipt by means of circumstantial evidence, provided that is corrected during investigation. To my knowledge, in no case circumstantial evidence is relied on in PC Act cases. So this was the crux of my argument the other day. But the whole issue has arisen because either the defect of complaint is no more or he declared as hostile. But regarding that hostility, I want to rely on one judgment. You will have to submit in the compilation. But my argument will be, in Indian law, the term hostility is foreign. Never it is used in the Evidence Act. That no witness can be declared hostile by any court because it has got its own implications. For that, you will have to kindly consider section 154 of the Evidence Act.
No, Mr. Nagamuthu, subject to what you may say. No, unless he is declared hostile, of course, we will hear you. How can he be allowed to cross-examine?
Yes, in English law, this is the judgment on that.
Because the same prosecution advocate for government advocate, APP has to cross-examine him. He leads and he cross-examines.
He can cross-examine, but witness cannot be declared as a hostile. Witness cannot be declared as hostile. Is my humble submission, but despite the judgment of this honorable court units that no witness can be declared as hostile, the practice is still prevailing in courts, declaring a witness first as hostile, then to allow the prosecution to cross-examine. That procedure is wholly illegal in Indian scenario, in the right of section 154 of the Evidence Act. But I will take you through section 154, then I will refer to the judgment also. 154.
Yes, we have.
The court may.
Yes, we have. The court may.
The court may, in its discretion, permit the person who calls a witness to put any question to him, which might be put in cross-examination by the adverse party. In a criminal case, adverse party is the accused when the prosecuting witness is in the box. Adverse party can very well cross-examine the witnesses, as per section 132 onwards, you can cross-examine. No doubt about that. Now, the prosecutor cannot do the cross-examination, but with the permission of the court, he can do it under 154. Section 154 does not say that the witness should be declared as hostile. Who is to declare him as hostile? Whether it is the court or the person who has called him as a witness. Let us say in the prosecution or the court, who has to declare him as hostile? The practice now is public prosecutor will make a request to the court to declare him as hostile. The court declares as hostile. Once he is declared as hostile, then the entire evidence is to be eschewed from consideration. That is my humble submission. But it is not done.
No,
there are several judgments.
There are several judgments.
Yes.
We say that even if a witness is declared as hostile,
Yes.
such part of his evidence,
Yes.
which can be treated as a trustworthy.
Yes. Any part.
You have to separate the chaff from the grain. And such evidence can be relied on. That is
true,
right from Kuchi.
Absolutely true, That is a position of law in India also. Though a witness is cross-examined under section 154 of the Evidence Act, any part of his evidence can be taken into account and relied on that the court can act upon No doubt about that. That is the law. But the question is, Murad, after treating a person as hostile, Murad, what was said, Murad, in several judgments, in my humble submission, is contrary to the judgment which I have now cited. 154 does not say that a witness is to be treated as hostile first. That too, Murad, declaration made by the court, and thereafter only, Murad, the cross-examination is permitted. That is what is practically being done, Murad, in the court. That procedure is wrong, Murad. It was so declared by this honorable court, but this judgment is not followed, and that is the reason why, Murad, today's problem has arisen. Because witness was told hostile, is not supported.
So what is the correct procedure, Mr. Nagamuthu?
Correct procedure,
In case he doesn't, his evidence is not in conformity with his statement.
Yes.
161 statement, whatever.
Yes.
What is the correct procedure?
He has to, the prosecutor has to seek permission to cross-examine, that is all. He is a witness for all purposes, like any other witness. There is no witness, like a hostile witness or unfavorable witness in India. Every witness is a witness. He is a prosecution witness. But normally, Millards, as per law, he cannot be allowed to be cross-examined by the non-adverse party. Adverse party has got right to cross-examine. But this is a peculiar provision which permits the person who calls him only to cross-examine. But the word hostile has not been used anywhere in the Evidence Act. More particularly in section 145. Your Honor, kindly have a judgment, Millards. Your Honor, kindly come to in compilation page 119.
So what you are suggesting is, if he is treated as hostile, his entire evidence has to go.
As per English principle. As per English principle. That we have not followed, that has not been incorporated in Indian Evidence Act.
Is it not high time that we follow our own law?
Millards,
How long will go on?
our law does not permit a witness to be declared by the court. Millards, this is a judicial function of the court. When the court says yes.
But then what is the procedure? How can a prosecutor cross-examine the witness called by him?
Millards, 154 simply says you take permission to cross-examine. For these reasons, permission is granted to cross-examine, but witness is never branded as hostile. Hostile means, Millards, it presupposes unbelievability of that witness.
What is that?
Witness cannot be believed. It presupposes.
Unbelievable.
Totally cannot believe this.
Hostile means it should go. That was the English principle.
No, hostile also could be mean hostile to prosecution.
Millards, there are two kinds of witnesses. Millards, as per English principle, there are two kinds of witnesses. One, Millards, is hostile. The other one is unfavorable to the prosecution. Two types of witnesses.
So in the context, it is unfavorable. In the context.
Millards, in this reference, it is said hostile.
Maybe 154 doesn't carry the expression,
Either hostile or unfavorable. There are two types of witnesses.
No, to cross-examine your own witness, you need permission of the court.
Court, yes. That is true, Millards. That is under 154. But it is not after declaring the witness as hostile. Millards, kindly see the difference between English law and Indian law. Millards, in English law, witnesses are branded into two categories. Number one, Millards, hostile witness. Number two, unfavorable witness. Millards, so far as hostile witness is concerned, he cannot be contradicted. He can only be cross-examined. Millards, section 145, Your Honor, kindly have a quick look into section 145 also of the Evidence Act. Your Honor, kindly come to section 145. Millards. A witness may be cross-examined as to the previous statement made by him in writing or reduced into writing and relevant to the matters in question without such writing being shown to him. This is out and out cross-examination and there is no contradiction elicited from him. He is not contradicted. First part. Ratma, kindly come to the second part. But if it is intended to contradict him by the writing, his attention must, before the writing can be proved, be called to those parts of which are to be used for the purpose of contradicting him. But so far as first part is concerned, it speaks only of cross-examination, no contradiction. But if a witness is hostile, as per English law, he can only be cross-examined, not contradicted. If a witness is unfavorable, but as per the latter part of section 145, he can be contradicted by means of the previous statement. Then, if he is so contradicted, Then Murad, his evidence is, credibility is impeached under section 155, this provision I already referred to your lordship, Murad, 155. Now, your lordship, I am not saying anything new, your lordship, kindly see the judgment. But all these things have been, Murad, like a research work done by this honorable court. Murad, your lordship, kindly come to the compilation page 119. Tatpal versus Delhi administration, two-judge bench, Murad. Honorable Justice R. S. Akaria has authored the judgment. Your Lordship may kindly come to page 131 of my compilation, Murad, paragraph 29. Top, Murad, on right hand side corner, my compilation page is there, 131. Paragraph 29 at the bottom. Since this vexing question frequently arises, and the observation made by this court in judgments in case supra do not appear to have been properly understood, it will be appropriate to clarify the law on the point. One, the term hostile witness, adverse witness, unfavorable witness, unwilling witness are all terms of English law. At common law,
What about tutored witness? Only known to Indian law.
Yes.
that is not Tanjurian law, Murad.
And both of us know better.
Tutored witness. Nagamuthu, Desi jurisprudence.
Tanjurian law, Murad.
Thank
I and his lordship belong to Tanjurian.
That is still more desi. Strong desi.
Put this.
Adverse witness, unfavorable witness, unwilling witness are all terms of English law. At common law, if a witness exhibited manifest antipathy, or attitude to the cause of the party calling him, the party was not, as a general rule, permitted to contradict him with his previous inconsistent statement, nor allowed to impeach his credit by general evidence of bad character. This rule had its foundation on the theory that by calling the witness a party represents him to the court as worthy of credit, and if he afterwards attacks his general character for veracity, this is not only malafide towards the court, but it would be enabled the party to destroy the witness if he spoke against him. Murad, I skip Murad few lines. Murad, kindly come to paragraph 33. Murad, I am skipping the other things. There were views, Murad, in support and against also they are dealt with up to paragraph 32. Paragraph 33, the rigidity of rule prohibiting a party to discredit or contradict its own witness was to an extent relaxed by evolving the terms hostile witness and unfavorable witness. There are only two types of witnesses. And by attempting to draw a distinction between the two categories. A hostile witness is described as one who is not desirous of telling the truth at the instance of the party calling him, and an unfavorable witness is one called by a party to prove a particular fact in issue relevant to the issue, who fails to prove such fact or proves an opposite fact. So there are two types of witnesses, hostile and then you let me kindly come to section 37, paragraph 37. The construction of these provisions, however, continue to cause difficulty, particularly in their application to unfavorable witnesses. In so and so case, these provisions were found to be confusing. That Cockburn CJ said that there has been a great blunder in drawing of it, and on part of those who adopted it. To steer clear of the controversy over meaning of the terms hostile witness and adverse witness, unfavorable witness, which had given rise to considerable difficulty and conflict of opinion in England, the authors of Indian Evidence Act of 1872 seem to have advisedly avoided the use of any of those terms so that in India, the grant of permission to cross-examine his own witness by a party is not conditional on the witness being declared as adverse or hostile in Indian law. Whether it be the grant of permission under section 142 to put leading questions or the leave under section 154 to ask questions which might be put in cross-examination by the adverse party, the Indian Evidence Act leaves the matter entirely to the discretion of the court. The discretion conferred by section 154 on the court is unqualified and untrammeled and is apart from any question of hostility. So no question of hostility so far Indian law is concerned. It is to be liberally exercised whenever the court from witnesses, demeanor, temper, attitude, bearing, or the tenor and tendency of his answers, or from a perusal of his previous inconsistent statement, or otherwise, you let me kindly highlight this, or from a perusal of his previous inconsistent statement, or otherwise, think that the grant of such permission is expedient to extract the truth and to do justice. The grant of permission, such permission, does not amount to an adjudication by the court as to the veracity of the witness. Therefore, hostile witness cannot be declared as hostile by the court. Therefore, in the order granting such permission, let me kindly consider this is very important. Therefore, in the order granting such permission, it is preferable to avoid the use of such expressions such as declared hostile, declared unfavorable, the significance of which is still not free from the historical cobwebs, which in their wake bring a misleading legacy of confusion and conflict that had so long vexed the English courts. So we have to avoid. So mere permission to cross-examine. And he can also be contradicted. Permission to cross-examine includes to contradict because it is provided in section 154. So therefore, my humble submission would be, no witness can be declared as hostile in India. But this judgment, Murad, is not followed. That is the wonder. Now you will kindly consider paragraph 40 of 39.
Is the hostile.
Declared as hostile, then the evidence cannot be put for any purpose. Because
There are so many judgments. There are so many judgments which says that the entire evidence cannot be discarded.
But I fully agree with you, Lordship Mullah. There are several judgments. That is a settled position of law. I got no quarrel over that. But my humble submission would be
And of a bench strength larger than this.
that there are judgments. Mullah,
Maybe
there
the
are-
procedure what you are suggesting is incorrect.
Yes.
You have to simply say, if the witness is, statement is
inconsistent.
inconsistent or not in support of the prosecution, then the prosecutor has to seek permission.
That is all.
Then the court will examine and grant permission or otherwise.
Yes.
This is the correct procedure, right?
Right position.
Hmm.
The significance, Mullah, of this is,
Hmm.
Mullah, if as it has been observed, Mullah, in Indian law, these words, adverse, hostile, and unfavorable witnesses, which had given rise to considerable difficulty and conflict of opinion in England, the authors of Indian Evidence Act seems to have advisedly avoided the use of any of these terms in India. Why they have avoided? They could have simply incorporated the principle.
Who are the framers of Indian Evidence Act? Again, Englishmen only, 1870.
72.
Stephen Muller, sir. But he has authored one wonderful book, Muller, about how he made this law. That book is very, very interesting to read. He has said about this also. Muller, in the judgment itself, Muller, there is a reference about the book.
St. James Stephens.
It is there. Muller, then you will Atma kindly consider paragraph 41.
No, maybe at that stage,
What is the effect?
maybe at that stage you should not say hostile, because before considering all evidence, you are branding a witness. Branding a witness.
As unfavorable
Yes.
or hostile. Not brand here.
That's the reason.
Muller, it is at the time of judgment, it is for the court to say,
Yes, yes.
yes, whether his evidence is credible.
He may be truthful also.
Yes, truthful also. Therefore, don't brand him.
So once you treat him hostile,
Yes.
the statements in favor of the prosecution can't be accepted.
Yes,
This is what perhaps,
court declared that he is a doubtful man.
and how can you rely on
You're
that?
branding him a liar.
Yes, liar. Yes, when he was a liar. So that finding can be given only in the judgment after hearing the
It
argument.
may, not, but in effect, the answer is in para 52.
But I will read that one. But I will read paragraph 42, then I'm not.
It's only
Tell this
some procedural aspect.
before.
The practice which has been followed for ages. That a prosecution witness, whenever the prosecutor finds that he doesn't support the prosecution case, he seeks leave of the court to cross-examine him.
He has to,
He has to.
necessarily.
So
But
as a matter of practice, before granting permission, he might be declared as hostile. So how it turns? Anything turns on that, because the consistent law is that his entire evidence is not washed away. Such of his evidence which can be found to be trustworthy and reliable.
My humble submission.
Even this judgment says so.
What
My
he's trying
humble
to say
submission is very
It
simple.
is not necessary to say at this
Not a question referred to us.
No, there is, because it's somewhat relevant, because when the defector complainant, the bribe giver, turns hostile, what is the position?
So many trials which have been.
Yes, 41.
Yes, Murad. Unmindful of this substantial difference between English law and Indian law on this subject, paragraph 41. Unmindful of this substantial difference between English law and Indian law on this subject, the Calcutta High Court in some of its earlier decisions interpreted and applied section 154 with reference to the meaning of the term adverse in English statute as construed in English decision, and enunciated the proposition that where a party calling a witness requests the court to declare him as hostile, and with the leave of the court cross-examine the witness, the latter's evidence should be excluded altogether in criminal cases. So if it is Calcutta High Court was available, once he declared as hostile, now there is a judicial declaration.
That view has not been found to be correct subsequently. You could find that this view is not correct.
True,
And on that also on the basis of English judgments.
absolutely, absolutely. Therefore, my humble submission will be, let us not follow the English law. English law is different.
What is the Indian law? The Indian law is same.
Indian law says no hostility. Don't declare by a judicial order at the threshold.
Only this judgment.
Right?
Only this judgment.
The judgment. Right? It's a, like a research. But I will not read the entire judgment.
Justice Sarkaria's judgment. Justice
We'll ask you to find
Sarkaria.
time, not we'll ask you to kindly read the entire judgment. It's like a research work, wonderful judgment. Not highlighting, not how it.
See, ultimately, what is the result? Para 52.
True, Murat. So what I am submitting, Murat, is, Murat, let no witness be branded as hostile. Let no witness be branded as unfavorable. Even before giving a finding on that, don't declare him. Murat, it is a judicial declaration made when the evidence is being recorded. When the evidence is being recorded, there is a judicial declaration that he is an unfavorable witness. He is hostile. No.
That is not a condition precedent for exercise of power under section 154.
Yes.
They can just say at this stage, permission is sought under section 154 of the Evidence Act.
Only to
cross-examine.
cross-examine. Only to cross-examine. Do that. But don't brand him at that stage.
Yes.
Hostile, the only meaning of hostile is hostile to the case of the party calling him.
No, who declares it? Court.
Yes,
So because that-
Court, Mullah.
at the request of the party calling him.
Mullah, he tells the truth in court. He tells the truth.
Prosecutor, firstly, he cannot put leading questions without the leave of the court. So in his examination in chief,
True, Mullah.
it is found that he doesn't support the prosecution case.
True.
Then at that stage, the prosecutor makes a request.
Yes, Mullah. To
This is
cross-examine.
a practice followed by declaring him hostile, not hostile to the justice, hostile to the party calling him.
Murat, so far as the witness is concerned, he is telling the truth in court. He is not telling any lie. He claims that you have called me on someone, I have come to the court. On oath, I am telling the truth. Why should you declare me as hostile? Why do you say that I am a false witness or I am a hostile witness at that stage?
Now, the problem is,
Yes.
we are starting with the presumption that the word hostile is an ugly word. But it has a reflection upon the character of the individual. It is not so. Hostility can arise of it. He is hostile to falsehood. I can be hostile to falsehood. I can be hostile to injustice. Where do you put the term hostile there?
Yes, my lord.
Can I be hostile to falsehood or not?
Yes.
Can I be hostile to injustice or not?
True, my lord.
Therefore, hostility this understanding has arisen out of treating the word hostile as an ugly word. It is not so. He is hostile to the party calling him to the witness box. He is hostile to falsity. Therefore, he is speaking the truth. It can be either way. Therefore, that
My lord, he is telling the truth.
And what is the truth in his evidence or not
Yes,
has to be found out by the court
yes.
from appreciation of his entire evidence
At the end.
at the end.
At the end, correct, my lord.
the long line of decisions which say that despite the court passing around, let us start with the understanding that such a declaration is not correct in law. Fine. But courts have repeatedly held, despite such declaration, the entire evidence is not washed away.
Right.
If that is so, the courts, despite declaration of hostility, have not treated him as a false witness. They are still prepared to give credibility to some portion of the evidence. Therefore, the courts have understood the term here not as a bad term, not as a term which connotes the bad character of the individual.
Why the distinction between English law and the Indian law needs to be highlighted is this. If a witness is treated as hostile, as per English principle, he can only be cross-examined by the party who is calling.
No. He can also be cross-examined by the accused.
No, he can, that right is always there, no. That is why adverse party can be cross-examined.
Merely because the prosecutor.
No, I'm not saying that, no. But he can be cross-examined. That right of the adverse party to cross-examine is always available. Normally, new right is created only for the prosecution to cross-examine. If a witness, as per English law, if treated as
I think
hostile.
if we read para 52, it will
No, I will come to it.
bring more clarity.
True, but I will highlight this. You not my
First, I think first we'll read para 52 and then
few minutes, few seconds, you not my permit me.
ultimately what has been held is in para 52.
But I will answer the query raised by his lordship. But the distinction is, but if a witness is treated as hostile, as per English law, he can only be cross-examined by the party who has called him. Only cross-examination, no contradiction can be elicited from him. If he is declared as unfavorable, there is another kind of witness, unfavorable witness. Unfavorable witness means Murad who has not stated what he stated in his previous statement. He is unfavorable, not hostile. The distinction is between unfavorable and hostile. Hostile means who is not speaking something which is expected of by the party who has called. That witness can be allowed to be only cross-examined to elicit the further facts. Only cross-examination. He cannot be allowed to contradict. That is also dealt with the judgment. Suppose the witness is declared as unfavorable, not hostile, unfavorable. Then Murad, he can be allowed to be contradicted by his previous statement. So that is the distinction, Murad, in English law between a hostile witness and unfavorable witness. Now, here, Murad, in India, we have been using the term hostile in every situation. We do not use the word unfavorable. As per English law, if the witness is only unfavorable, he can be contradicted with the use of the previous statement. But in no case we use the word unfavorable in India.
That is because these minor distinctions of syntax, the meaning, etc., being a foreign language, we have lost. There is a law which says that the practice of the court is also the law of the court. Correct? Therefore, if we have followed in a long line of decisions, maybe loosely understanding what we mean, mixing of both unfavorable, adverse, hostile, etc., then that position should be left undisturbed.
Yes, ma'am.
Therefore, Nagamuthu, if you read para 52.
Yes, ma'am. Yes, ma'am. From the above conspectus, it emerges clear that even in a criminal prosecution, the witness is cross-examined and contradicted with the leave of the court, not after declaring as hostile. by the party calling him, his evidence cannot, as a matter of law, be treated as washed off the record altogether. It is for a judge or the fact to consider in each case whether as a result of such a cross-examination and contradiction, both are there, contradiction, the witness stands thoroughly discredited or can still be believed in regard to a part of his testimony. If the judge finds that in the process the credit of the witness has not been completely shaken, he may, after reading and considering the evidence of the witness as a whole, with a due caution and care, accept in the light of the other evidence on the record that part of the testimony which he finds to be credit-worthy and act upon it.
So this is in reference to the Calcutta High Court, wherein Calcutta High Court holds that once a witness is declared hostile, his evidence is totally washed away.
They followed one of the English principles.
And this judgment is also following certain other English judgments.
Yes, Manoj. So therefore, my humble submission would be, Manoj, as it has been held in this case, there are two types of witnesses, unfavorable or hostile, but in no case will we declare any witness as unfavorable.
Hostile or not.
It's very interesting.
This is very interesting, but then you can't read a judgment in piecemeal.
No.
You have to read in entirety. This is in
Yes,
this is in answer to what the Calcutta High Court holds in para 41.
In para 41, Manoj, the Calcutta High Court said that because the witness is declared as hostile,
His entire evidence is required to be excluded.
washed up, they applied the English principle.
English principle.
Now, this court say, don't declare him as hostile. Allows him to be cross-examined or contradicted. Then keep it open for you to decide. At the end, you may decide from out of his evidence and all the other evidences, whether a part of the evidence can be taken into account, can be believed. You keep it open. That's what the judgment says. Calcutta High Court followed the English principle.
So therefore, mere declaration of a witness as a hostile does not wash away his evidence. And this principle also is on the basis of the full bench of Calcutta High Court, which relied on two English judgments,
Yes, Manoj.
the King versus Norton and Percy William versus Adams.
Yes. Yes, Manoj. Therefore, I am
So
submitting.
merely declaration, it's only a matter of practice, procedure, followed for years together.
Practice of being followed by the trial court, Manoj, is found to be not in accordance with Section 154 as highlighted in the judgment. But I think I am justified in placing before this honorable court that this practice, which is contrary to 154, should go. But why should a witness be declared as hostile? Why should I am coming to the court as a witness? I tell the truth. But even without examining the correctness of my evidence, you declare me as hostile, you say that I am unfavorable. But it is a stigma on me. Therefore, kindly don't do that. It is my.
He is declared hostile only when he doesn't support what has been stated by him either in 161 or 164.
But I am not expected to speak what they expect. But I am here on oath to tell the truth. I am telling the truth as far as I am concerned.
Therefore, you are hostile to falsehood.
Yes.
If you are hostile to falsehood, is it a credit to you or a discredit to you?
I am favorable to truth always.
Therefore, unfavorable to falsehood,
Yeah.
adverse to falsehood.
Yeah.
So these terms can be used both ways in conjunction with the opposites.
True.
Extreme opposites
True.
to mean different things. Hostility, we don't think is a bad term which reflects the character of the individual. In fact, see, why witnesses turn hostile? One, either because of their desire to speak the truth.
He has got some instruction.
Either.
What are these?
No, does he want to turn you hostile?
Or is he hostile to you?
Unfavorable.
See, the word hostile is used in the loose sense. It is used in the word loose.
Interpret to this extent. On what basis the witness can be declared in case even if it does not favor to the prosecution? The answer to this query, that in case even if the statement under section 161 of the CRPC that has been recorded, which he never disclosed to that extent. Can he be declared as a hostile? So this is the important question that needs to be given replied by this honorable person.
He is also right. But I do not know what is contained in my 161 statement. It does not contain my signature because my signature is not applied on section 161. There is a bar. Something is written there. So they say, they read that I am asked to tell the truth on oath. I say the truth. They say, no, it is not contained here. Therefore, he is hostile.
So if at the end of the trial,
Yes.
the court finds that you are correct,
Yes.
then court will
Accept.
give a finding
Yes.
that the evidence of such and such witnesses is truthful and the prosecution case is false.
Yes.
In which case, what happens?
Nowadays, why that word is being used by the judges is,
The prosecution.
Yes.
nowadays, why that word is being used, it is in a loose sense, in the sense that if the witness is hostile to the prosecution's case, he is declared hostile.
Declare hostile.
That is not correct in the legal sense.
That's what I am submitting. Don't declare by a judicial order.
In a loose sense, it is being used.
On the contrary, if the evidence of such witnesses is found to be trustworthy, there are matters where at the end of the trial, there would be strictures against the prosecution. That the prosecution has falsely made out this case, so there was nothing against the accused.
Yes, yes, yes.
Yes. So at that stage, the so-called stigma
I am speaking Marathi. In trial courts, what is happening? The witness is treated as hostile. Non-Marathi, he is seen as an untouchable. No, he is hostile witness. Don't look into it.
Because every time they
We
pass
are
an
not
order,
hostile towards the settled principle of law.
Basically,
No, but then this court right from Privy Council has been using the word hostile witnesses.
That's hostile.
Hostile has been used right from Privy Council. It is not as if that only the magistrates use it.
no, my lord. In case you will the magistrate is of that point of view, that is naturally on the basis of the statement recorded by even the police, he should be immediately declared as a hostile. What is his position in the society? But he is going to be treated as a
Who will come to the court?
Maybe to that extent he is right. He is treated as something like a, class.
Suppose, I am standing in the bus stand, I see an accident.
What is actually,
But I am summoned to the court, I come and give the evidence.
what is the evidence?
By a judicial pronouncement, you declare hostile. When I return, you say that you are an unfavorable person. Go back.
No.
Who will come to the court hereafter to give you evidence?
And see, in fact, once you accept the position
Yes.
that despite declaration of hostility, the portion of the evidence can be relied upon, that is the law right down. Once the portion of the evidence can be relied upon, that means no stigma is attached. If stigma is attached, the courts will not be relying upon any part of his statement. We continue to rely upon we ultimately the court analyzes the evidence and relies upon it. Once the court relies upon it, where is the question of you declared me hostile, I have become an untouchable in society. Now, how can this contradiction be?
And there can be cases of both the types. At times, the prosecution may, go on recording statements, similar statements of so many witnesses. There are also times when the witnesses are win over. Yesterday, I had a criminal case wherein there was a dying declaration of the mother who was deceased. The daughter was witness there. But then at the time stage of trial, after 3 years, then she was residing with father and she did not support the prosecution case.
You are aware of Uday Kumar case, hon'ble University. His father came. Now let any advocate answer this question. His father cremated the dead body of his son. In court, he was put under pressure. He turned hostile and said, he is not my son.
That is the
So that will depend on facts of each case.
The system, we can't.
Therefore,
You please find a system which is free from all these,
Therefore, now, what is wrong in declaring that father as hostile? What's the,
What we say is, don't declare him as hostile and allow him to be cross-examined.
if a person, if a witness can, if this is what you can do to the witness, sir. Both sides, sir. Police, what police is capable of doing, now the defense is more capable of doing if they are very powerful.
But in-
Therefore,
there is a reason why not we have got answer to the
let
point
us
the
not,
other day.
let us not treat the word hostile as stigmatic to the witness so long as a hostile witness statement can be relied upon by the court.
Respond to this would be one. If he is a hostile witness, then the implication is this. Hostile is not dealt with in Evidence Act. We draw this word only for English law. As per English law, if a witness is.
But now that is clarified by this judgment. This judgment to which you are relying.
Yes.
It itself says that.
Judgment say, don't declare him as hostile, allow him to cross-examine. Then take any part of his evidence as a trustworthy. That is what section paragraph 52 says. Paragraph 52 does not say that the witness should be treated as hostile. After being declared as hostile, his witness can be believed. It doesn't say so. Paragraph 52 says, allow him to be cross-examined. No question of hostility, no question of declaring him as hostile. Take any part of the evidence after a cross-examination by the prosecutor.
All right, please proceed, Nagamuthu.
Yes,
Please
Madam.
proceed.
Now, Murad, that is my humble submission. My submission would be, Murad, in response to Honorable Justice Ramasubramanian. My response is this: if a witness is treated as hostile, the legal implication is that that witness can only be cross-examined, not contradicted. If you are drawing the English principle, if the witness is declared as unfavorable, then only he can be contradicted.
So Nagamuthu, even this judgment says that it is preferable not to. Doesn't say that it cannot be done. It cannot be declared as hostile. Again, come to page 742. Therefore, in the order granting such permission, it is preferable.
Yes, Murad. If you prefer to use the word hostile, allow him to be cross-examined only.
This court doesn't say that it is not permissible to use the word hostile.
But what I say is, not preferable. But I think that it is only
It's only a matter of practice which is followed by courts for ages.
But preferable, I fully agree, Murad. If the court prefers to use the word hostile, then the implication is that the witness can only be cross-examined, not contradicted. If he is declared as unfavorable, he can be contradicted.
That distinction has been found not to be correct by the court in the para 52 itself.
52, Your Honor, kindly see, the term hostile is not used. Your Honor, kindly see 50.
52 is an answer.
From
52,
the conspector,
52 is an answer to 41. 41 says that once a witness is done hostile, his evidence cannot be read at all.
for my settlement, let me read 52 minutes. Even in a criminal prosecution, when a witness is cross-examined, that is all. Uncontradicted, that is all. That these two terms of cross-examination and contradiction are dealt with in section 154. It is permissible under that provision. With the leave of the court, by the party calling him, his evidence cannot, as a matter of law, be treated as washed off and record of the record to altogether. Now, this is strictly as per section 154. Under 154, permission is given to cross-examine and also to contradict. If you declare him as hostile, you cannot allow him to be contradicted.
That position is not accepted in India. What is, if you read the judgment in entirety, this is not a position which we accept.
What is highlighted? I read only piecemeal in the judgment, but I leave to this honorable court.
You have to read the judgment in entirety.
Yes, Your Honor, kindly consider that in its entirety, because I only bring it to your lordship's notice that there is a judgment saying this. But it is for your lordship to decide.
All right, all right.